You've just joined us. You're watching Newslink on DSTV channel 403. Now, former President Jacob Zuma is in the High Court in Pietermaritzburg this morning. He's launched a private prosecution against prosecutor Billy Downer and journalist Karyn Maughan. Zuma is accusing Downer of leaking his doctor's note to Maughan. He says this is a breach of the NPA's Act. Let's get some analysis now ahead of that particular matter to be heard later. Legal analyst Mpumelelo Zikalala from Zikalala Attorney joins us. Mpumelelo, as always, good morning. Thank you very much for your time. You know, this particular case is of interest to many. It's a former president challenging a seasoned journalist and a senior prosecutor. But before we get to the merits of the case, let's take it back to the NPA's decision not to prosecute. They cited lack of evidence. What did you make of that?
They would have basically looked at the facts in front of them. Then they said, we are not going to get a guilty beyond reasonable doubt conviction in this case. So from what we have, we're not going to prosecute. Now, the Criminal Procedure Act is very clear that when that has happened, you can privately prosecute. And Section 7 up until Section 18 generally regulates how that particular process would happen. But once you've been given a certificate, basically a decision saying that we're no longer going to prosecute this matter, then as a private individual, it is your right to privately prosecute the person concerned and take the matter to court as if you were the prosecutor.
And then to Section 41, subsection 6 of the NPA Act that everybody's talking about. It's pretty straightforward, read through it, until we get to Section 42, which deals with the limitations of liabilities. Just take us through your interpretation of these two sections.
Firstly, it deals with the offences which are there. In the broader sense, it simply says if you haven't been given authority to give out certain information, you are not allowed to do that. Now, you must take a step back and remember, within the NPA, there is someone who is a designated official spokesperson, the official communicator between the NPA and members of the media or any other third individual that would need to communicate with. Now, it then mean that as a prosecutor, you ought not to communicate with journalists in your line of work, because at the end of the day, you're not really employed to do exactly that. But it would depend in this case as to what type of information was there. Was it readily available in other means, or is it information which was in the sole sort of custody of the NPA that Ms. Karyn Maughan obtained, and whether indeed they obtained it illegally? And if it's proved that indeed it was such, then the offences that follow, the punishment which has been prescribed, which is either a fine or a maximum imprisonment of 10 years, will then follow if they are found guilty. But before you actually get to that, you need to prove all the elements that are there, meaning it is the former president that will have to prove beyond reasonable doubt that all the elements of the infringement of the NPA Act have been there, and Advocate Billy Downer is the individual who is guilty, or ought to have exercised caution and make sure that they stick to the NPA Act but fail to do that, and hence he would be found guilty.
Then when we look at Section 42, speaking of the limitations of liability, no person shall be liable in respect of anything done in good faith under this Act. I mean, that itself is very broad. I'm sure one would think that it would be difficult to prove that it wasn't done in good faith, if indeed done.
But if there's a certain provision which prohibits you from doing a certain conduct, then you stick to that first before you move on to other things. Now, the good faith in this particular matter would be after the information is available within the court file and is readily available, then if it can be obtained in other means, and then I give you that particular piece of information, that has been done in good faith. You would have received the information anyways, regardless of the fact that I've given it to you or not. The important part in this case is, did you disclose vital information as the NPA, not even vital information, just information in general, which ought not to have been in the court file at that particular point in time? Or did you exercise any favor in providing this information to any other individuals other than the person who works within the NPA, when you are not a designated individual or information officer who ought to distribute that type of information to third parties or to the media? I think those are the technicalities or modalities in which the court will have to deal with when this particular matter goes to trial.
But then your prospects of success, I know I'm putting you on the spots here, the prospects of success for this particular matter, because I hear the technicalities that it now matters who the individual is, that here you are an official, you work within the NPA, there might be a technical difficulty in that respect as to oppose perhaps the spokesperson or anybody else sharing the documentation that Karyn Maughan could have easily retrieved from just walking and going to court herself. So what are the prospects of success here?
Maybe let's separate the two matters, because there are two matters which are in front of the court today. And let's start with the urgent application by Ms. Karyn Maughan.
Yes.
On that one, on the agency, I don't think she's going to succeed on the agency part, because there is a section within the Criminal Procedure Act, which is Section 106, which deals with the no charge to prosecute. So if you're going to say that the person who's prosecuting me does not have a title, why not use a particular avenue instead of going to court and asking the court to do an extraordinary step that could have been dealt with within the trial? And the second part, when it comes to the lack of agency, is what did you do from the date in which you received those particular summons up until now? Did you wait up until the last minute? Is it self-created agency, of which I think the court will then say yes? Now, moving on to the case against Advocate Billy Downer, the technicalities would be towards this. Am I the designated individual? Can you be able to prove beyond reasonable doubt that the information was solely within my exclusive knowledge and exclusive possession or custody? If you can be able to prove that, then your chances of success are high. But if you can't, then you're going to have a problem. Now, what we've seen is that there are various email exchanges that have taken place within a number of parties. So one of the defense from Advocate Billy Downer would be, yes, the information was provided to me, but not only to me. What proof do you have, which is beyond reasonable doubt, that I'm the only person that had the letter, I'm the only person that communicated with Karyn Maughan pertaining to this particular matter? If you can't prove that, or you are able to create instances of doubt, then I don't think that the former president will succeed.
It seems like a difficult road ahead. Mpumelelo, thank you very much, as always, for your time. That was legal analyst Mpumelelo Zikalala.